Hi everybody. Let's see how we go. As I said, we've got a few funny animations just with some of the titles on the slide, so I really apologise for that, but please just ignore them. Just to introduce you to me, I'm a safety consultant. I've been working for about 15 years in safety, and I'm also a practicing lawyer in health and safety. Contractor management is an issue that I have been very passionate about for a long time. I find the way that we handle contractors in the workplace to be very burdensome, doesn't reflect the expectations of the law, creates unnecessary burden on both contractors and employers, and I think in fact increases the liability on principal contractors when engaging contracts. And it also really flies in the face of why do we engage contractors in the first place. So we're going to run through some slides. My understanding is if you want to ask a question, you type that question in. That question will then be forwarded to me and we can respond to those things. So look, we'll run through it. I'm going to run through what is the position of the law. In 2012, there was a seminal case. Baiada Poultry went all the way to the High Court and appealed a decision in respect of its obligations owed to its independent contractors. I will make a note. Let me just move that slide. I will get better at this as we go along. Please note, the following discussion does not apply to high-risk work in the construction industry. There are regulations in relation to principal contractors managing construction sites for defined high-risk work. Please go and refer to those regulations because they do alter the position which is espoused in these cases. The other thing is, this position and what we're about to discuss looks at independent contractors. It does not apply to labour hire arrangements where you basically bring people in to do the work of your own employees, and they are to be treated as your own employees and basically absorbed into your health and safety management system. So please understand this is in respect of independent contractors who are being brought in to do work on behalf of your company. So if we have a look at it, oh, I think I'm pressing the wrong thing, sorry. There's that animation, sorry about that. Okay, so essentially management of contractor safety. We know that in all Australian workplace and OH&S jurisdictions there is a duty to ensure, so far as is reasonably practicable, the health and safety of independent contractors. The duties owed are to our employees and they include independent contractors. But what does that actually mean in practice? I have found that in years gone by, the position was espoused that the same duty is owed to your contractors as it is to your own employees. That always struck me as being a very hard to understand position because there is a big difference between the engagement of an independent contractor and your own employee in respect of how much control you have over them, the kind of work they do, the knowledge of the work that they do, and so forth. And it always troubled me, even prior to the 2012 decision of the High Court, and I'd actually written an article about that very thing prior to that decision saying this just doesn't seem to make sense. We bring in an independent contractor who's doing work that is not our core work, but we seem to be being expected to manage their safety in the same way as our own employees, and to me it just never really made sense. So if we have a look at Baiada, now Baiada Poultry processes chickens, and essentially what it does, brings the chickens in, processes them on the plant, in their plant, and sends them out. So there was an incident where, if we just move this on again, so if we look at the incident, the players in the incident were, there was a farm, Hooden Farms, that grew the chickens. There was a company, DMP Poltech, who were engaged by Baiada Poultry to go to Hooden Farms, catch the chickens. As a party haulage was a transport company who were engaged by Baiada to go to the farm, take and then transport the chickens to the Baiada plant. So you can see there were 4 parties in this relationship. They were all contract relationships and they were all independent contractors. Hooden Farms, Poltech and as a party haulage were all independent contractors engaged by Baiada to undertake their element of the job. So the relationships, Hoodin supplied Baiada with chickens, so they grew them. Baiada contracted Poltec, as I said, to go to Hoodin's, catch and load the chickens into these pallets, which are then modularised, and load those pallets onto the Azzopardi trucks for transport. And then Azzopardi would take those modules to Baiada to drop the chickens off. So they all had a quite well-defined or a very well-defined role in the chain of what was actually happening in this situation. So what actually happened? At Hoodin's farm, a guy by the name of Jason Dent from DMP Poltec was loading a module of pallets onto an Azzopardi truck. One of those modules became stuck. Mario Azzopardi went to the vehicle, attempted to help get it unstuck, when another module fell off the truck, fell onto him and killed him. And on that basis, Baiada was prosecuted by the VWA and found guilty, sorry for the animation, and found guilty in the county court for failing to discharge its obligations as an employer under Section 21 of the OH&S Act. They said, well, their defence was, Baiada said it was entitled to rely upon the expertise of its independent contractors to take appropriate steps to ensure the safety of employees, meaning the contractors, employees and others. In engaging DMP and Azzopardi, it had discharged its obligations, safety obligations. So basically it was saying we've engaged contractors who are doing what they do, experts at what they do, and because that's not what we do, we have used these contractors to undertake this work and manage the safety aspect. They were found guilty anyway, and they appealed. So, so this was their defence in the Court of Appeal, was this reliance on their expert contractors, and they were saying, well, we've met our obligations by using expert independent contractors. The appeal was dismissed, so they lost that appeal, and the court said that because Baiada defined and directed the chicken catcher's activities, they controlled the days and times when chickens were picked up and travelled to farms. Interestingly, the court found that neither contractor had greater specialist expertise in loading or unloading crates than the employer, than Baiada. There was a real risk that a bystander might be seriously injured or killed, and it was foreseeable. And the measures necessary, such as traffic management, were well known to the employer and Baiada and throughout the industry, and it was practicable for the employer to require and enforce them. So the Court of Appeal basically said, no, you had a level of control over these contractors, you knew what the solution, the risk was real and obvious, and you knew what the solutions were, you should have put them in place. Baiada then said, well, we're not happy with that decision, and we don't think that that's right, so we are going to appeal to the High Court. And, sorry about the animations. So, and the appeal in the High Court was upheld. So essentially the High Court, what they did was they looked at a central issue around control, and they really looked at the contract relationship. And one of the key principles was, while a principal contractor has the right under contract to exercise control over its contractors, so in a contract, you bring in a contractor and you say, we have the right to direct you, the question to be answered is whether that is a step which is reasonably practicable for a principal to take to meet their obligations to provide and maintain a safe working environment. And they looked at issues like the knowledge of the principal contractor to direct an independent contractor. But not only the knowledge, and this decision went further than previous decisions looking at this matter, and we will look at those for previous decisions. It actually said, well, even if you have knowledge of how an independent contractor is to do their work, the nature of a contract is that you have engaged this person to take that responsibility and to manage that issue for you, and the cost and effort of you to go and manage that contractor in the same way as you would manage your employees is opposite to the whole nature of the contract. So this decision really took the matter right through to the end. Previous decisions had looked at things like knowledge and expertise. This decision basically said, well, even if you know how an independent contractor does their work, the nature of the contract is such that you have handed over the job to the contractor and they have a responsibility to manage that aspect of the contract. So if we move on from here, so the High Court confirmed in this case that both contractors had expertise. So as a parties had expertise in trucking, DMP Poltec had expertise in catching the chickens and loading them. And interestingly, and this goes to this point about it's not just about knowledge, it's about control and the nature of contracts. And it says, and just because Baiada had safety procedures for its own employees, we can imagine at their processing plant, they would have had traffic management. They would have had procedures in place around loading and unloading of trucks. Just because they knew how to control the risk, it did not follow that the legislation called for them to require its contractors to put them in place or to check if whether those procedures were being observed. So this decision went really far in terms of really saying, how does the contract work and what sort of control are we retaining and when is it appropriate for us for that control to be, handed over as such. So what if the principal has knowledge? So contracting out the obligations, people say, and I was in a session not that long ago and WorkSafe were there and saying, it's not possible to contract out your obligations. That's true. It's not possible to contract out the obligations owed under health and safety legislation. They are non-delegable duties. But engaging qualified contractors to undertake work is a method by which those obligations can be discharged. So to explain that, we say, look, I'm an employer, I need certain work done, and to make sure that work is done safely, I engage an expert contractor to undertake that work, or I engage a contractor to do that work, and I engage them on the basis that they will manage the safety risk that goes with that work. So it's not saying I'm sidestepping my obligations. The case is not saying, oh, I'm contracting out or I'm delegating my non-delegable duties. It's saying you are using a contractor to actually meet your obligations. And you can think of many examples like this. You're a factory and you're processing an item and you need to have work done on the roof. Well, the best way you can an item and you need to have work done on the roof. Well, the best way you can meet your obligations to manage work at heights is to engage a contractor who is experienced and understands about working at heights. So we need to change our thinking away from this is not about contracting out duties and this is not about delegating non-delegable duties, and that's quite a different way to think about the issue. So if we think about the sorts of processes that we have in place today in contractor management, and I must say this is the reason why I have gone on about this issue for really since the Baiada decision in 2012, and as I said even before, it has always troubled me, the processes that we put in place when we engage contractors around. We collect their safe work method statements, we review them, we sometimes change them, we tell our contractors how to undertake their work. We give safety instructions to our skilled and experienced subcontractors. We check whether those instructions are being followed, and then we require compliance with those instructions. And the High Court actually looked at this decision, these practices, and said, well, is it an obligation to provide and maintain? Does that obligation oblige you to do those things? And this is a really interesting statement from the High Court, and I think it very much sets it out in a very sort of keeping it real way. And it says, the High Court talked about, the judges talked about, you're a householder and you get an electrician and a plumber in to do some work. And then they said, assume that the electrician and the plumber are expert and experienced in their fields. Assume that they know where the pipes are in relation to the wire. Any attempt by the householders to deliver a speech about safety would be likely to prompt aggressive responses from the contractors. And I've seen that in workplaces where you get an independent contractor to come in and then you suddenly turn around and say, but I'm going to tell you how to manage your safety. And quite rightly, those contractors get quite frustrated. And I think the most concerning aspect of that as well is that we actually start to draw liability away from the contractor and onto ourselves as principal contractors. As soon as we start to interfere with contractors' safety arrangements and start to direct them in how they do their safety, well, we've just taken on liability. So not only is it, you know, not a good look in terms of saying, well, I've got an expert contractor, why should I be telling them how to do their job? It's also legally risky to start doing that. And unfortunately, there is now, and I just filled in a form the other day that did this exact thing, wanted me to explain to the principal employer how I would be managing a whole range of risks. And quite frankly, I think that puts the principal at risk, because if I answer that question and something goes wrong, it's like, well, did they tacitly approve that? If they come back to me and say, well, I want you to change that, there's definitely an issue there. What this case did was it really recognised, you know, the whole purpose of bringing in a contractor is because you're going to get them to do work that you don't do. And to interfere with that, it doesn't make sense in a contractual sense, and it doesn't make sense in a liability sense. So the precedent, there was actually, when the Baiada decision was handed down in 2012, there was sort of this brief aha moment. Sadly, we seem to have moved away from that. And as I said, I see a plethora of online contractor management tools and paper-based questionnaires which are so burdensome and difficult, and, you know, put contractors to unnecessary trouble on cost and put principals to unnecessary trouble on cost. But even before the Baiada decision, there was significant precedent from the High Court. Now, I'll just say, I got asked a question a little while ago, does this decision apply to all jurisdictions? A High Court decision applies to all jurisdictions. It's the highest court in the land, and if a decision is made in the High Court, then it applies to every state. So we can rely on the legal principles no matter where you're located. So as I said, there was significant precedent prior to actually this decision being made, and these were a number of the cases, and we're going to just run through them. And sorry, I'll just go back there. So Stevens and Brodrib, Leighton Contractors, Kirk was another one that made a very significant impact, and people will probably remember that, and another one, Fortescue Metals, which was actually the Supreme Court of Western Australia. And so this body of law around recognising the boundaries between contractors and principals has actually been around for quite a long time, and it's gradually been, you know, developed up and refined. And this decision of Baiada in 2012 really made it very clear that, you know, definitely where it's an independent contractor undertaking work that the principal doesn't understand, there will be a real boundary. But even where the principal does have knowledge of the independent contractors work, the cost and effort of interfering with or asking to see and monitoring and supervising a contractor's work just makes it not reasonably practicable to do. So if we look at Stevens and Brodrib, the legislation does not import a duty to retain control of working systems if it is reasonable to engage the services of independent contractors who are competent themselves to control their system of work without supervision by the entrepreneur. So basically, if you engage an independent contractor who is competent, now we'll look at what does that mean. Some people would say, well, I need to send them a 50-page questionnaire to make sure they are competent. The High Court looked at that issue and said, look, if you are engaging a plumber, they're a licensed plumber, you know, representing themselves as a competent plumber who is licensed, well, you're entitled to rely on that. You don't then need to question the ins and outs of how they're actually going to lay their pipes and do all that kind of stuff. And it went on to say, this case went on, and this was in 1986, so this is a long time ago, to import a duty akin to that of an employer to retain a degree of control over the work of contractors would be inconsistent with the relationship between principal and independent contractor. And I think that point there is really important to make, because we need to be not falling back on, well, you know, if I know how to do the contractor's work, so if I'm engaging a contractor to come on site like Baiada had an understanding of traffic management, well, does it follow that I still have an obligation to control them? And this case said no, it does not, because it's inconsistent with a principal and an independent contractor and the reason why you contract things out. If that duty was to be imported, well, you might as well not contract it out. You might as well get your own people and train them and do it yourself. Okay. Leighton Contractors. This is one where Downview was subcontracted to do some concrete pumping, and a chappie by the name of Brian Allen Fox was injured. And this is a High Court case, and the common law does not impose a duty of care on principals for the benefit of independent contractors engaged by them of the kind which they owe to their employees. So it's very clearly saying there is a difference. There is a difference between the duty and how that duty is discharged between employees and independent contractors. Once an activity has been organised and its operation is in the hands of independent contractors, liability for negligence by them, the principals, within their by them within their area of responsibility is not borne vicariously by the principal contractor. So again, making that distinction and saying the duties owed are different between your own employees and an independent. This is a development of this idea about provided that the contractor was competent. Now, how do we determine competence? And I would not like to see this reinforcing the view that we have to be sending out complex questionnaires and asking all the ins and outs to prove that competence. But we can do that in a number of ways by, you know, making sure that they are licensed, that they're insured, that they are, you know, even by referral. So provided that the contractor was competent, provided the activity, this was of concrete pumping, was placed in the contractor's hands. So that says we hand the job over to the contractor. We as the principal are no longer involved. So I work in a processing plant. I bring in a crane contractor to do crane work. And I say, there's where you need to go and do your work. Here's the job, and I step back. And I let the crane operator sort out their rigging and chains and traffic management and all of those things as to how they're actually going to manage that issue. So Downview was not subject, which was subject to an ongoing general law obligation with respect to the safety of the work methods employed by the contractor or those with whom the contractor subcontracted. So essentially, the principal contractor, Downview, was not required to monitor or review the safe work method statements of the contractor or that contractor's subcontractors. Okay, so it really is very, very clear, and I think, you know, very much puts into question this current practice that we have within the safety industry of all of this collection of safe work method statements, all of this review, monitoring, supervision, and all the rest of it, which, you know, quite frankly, is hugely costly. It's not practicable, and as I said, I consider increases our liability. This is Kirk. Now, Kirk was the one where we had a farm manager who rode an ATV across the side of a hill, rolled the all-terrain vehicle, and was killed. And Kirk, he was the owner of the farm. He hardly ever went there. But essentially, he was prosecuted on the basis that he didn't ensure the health and safety of the manager and direct him in how to ride the all-terrain vehicle safely. The farm manager was very experienced, and Kirk had far less knowledge than him. And the statement they made was, "It is absurd to have prosecuted the owner of a farm and its principal on the ground that the principal failed to properly ensure the health, safety and welfare of his manager, who was a man of optimum skill and experience much greater than his own." So it wasn't reasonably practicable for Kirk to give him directions because he didn't have you know, this man was far more experienced than him, and you know, for him not to be able to rely on that, and I think it's fairly strongly worded, it is absurd. Fortescue Metals. This was the case where Fortescue Metals engaged a company to come out and build some accommodation on its mine, dongers, for its miners. Now, it was in a cyclone-rated area, and the dongers needed to be built so that they could withstand cyclonic winds. And essentially what happened, the dongers got built, or the accommodation got built, the cyclone came through, blew them over, and someone got crushed. And essentially Fortescue said, look, we got in independent contractors who were the ones who were skilled and qualified in knowing what the building standards are to build this accommodation so that it would withstand. They knew that we were in a cyclone area. We should have been able to rely on them. And the comment by the Supreme Court was, again, whilst the respondents, Fortescue Metals, could not delegate or contract out of their duties, that's exactly on point. We are not saying they just went, well, we're delegating it to you and we're contracting out. They are actually ensuring they meet their obligations by using a qualified person. So they could perform them by ensuring that an appropriately experienced and qualified person was retained to deal with matters beyond their own knowledge and ability. This is such an important point in this legal issue, is it is not about saying I'm contracting out or I'm delegating. It's about saying I am using expertise to meet my obligation. And in doing so, you know, meeting the obligations that I have under the legislation. Sometimes people say, oh, well, you know, they sort of mix it up with a moral obligation. Well, quite frankly, you're meeting your moral obligation by getting the right advice. It would have been hopeless for Fortescue Metals site manager to wander around and make any kind of judgment about whether these dongers were safe or not. And they were actually meeting their obligation by getting in the right advice. And we do that all the time. Okay, so Baiada findings in 2012. A key element of the High Court's findings was that even if the principal could issue instructions to its contractors in respect of safety, is it reasonably practicable to do so given knowledge and the nature of the contractual relationship? And the nature of the relationship is, I have a job, I bring you in to do that job, I hand over the job to you, and I define the things that you are responsible for, and I rely upon you to actually undertake those things. And I also, in most cases, use your expertise and knowledge to help me discharge my obligations so that those risks are actually managed. So Brodrib, back in 1986, really was sort of saying, look, if you engage an expert contractor, then you know, yes, you're able to not delegate those duties, but use a contractor to meet those obligations. But Brodrib actually said, if an entrepreneur engages independent contractors to do work that might as readily be done by employees in circumstances in which there is risk to them of injury from the nature of the work, and where there is a need for direction and coordination of the various activities being undertaken, the entrepreneur will come under a duty to prescribe a safe system of work. Now, Baiada went further than Brodrib, and it said, look, even if you engage a contractor, an independent contractor, where you have knowledge of how that independent contractor works, you're still, by the nature of the contract, able to define who is responsible for managing the safety in that situation. The important point is that the work is defined and handed over to the contractor. Now, this need for direction and coordination of various activities being undertaken, yes, employers will retain some control, and they are responsible for the matters over which they have control. And we'll actually have a little closer look at that in a second. But yeah, basically Baiada went even further and said it's not just about the level of knowledge. It's saying, what is the point of contracting out, not contracting out the duties, but contracting out a job, and then saying, but I'm going to interfere and I'm going to tell you how to do that work anyway. Now, control. This is the key element, a really significant element, is matters over which one has control. There is no doubt that employers will be responsible for contractor safety where they have direct control, say for example labour hire and temporary workers who, supplement your workforce. The defining characteristics of these relationships is that the worker is under the direct and total control of the employer engaging them. They're the same as your own employees. So please don't walk away from this webinar and think, okay, I don't need to worry about my labour hire. You would all know, yes, you do, because they are essentially the same as your own employees in terms of you direct them, you tell them how to do their work, you give them equipment, all of those things. These are all cases also where a principal contractor also has responsibility for risks arising from their undertaking and things like site safety and so forth. So it's not that we say, oh, we've got an independent contractor, we can just let them loose. We need to say the things I have control over as a principal, I still have control over some things. These are some examples of when the principal was found guilty, and I think when you read them, you go, well, of course they were, because they had control over the matter or the issue that caused the injury. The principal was held liable, so James versus Roads and Traffic Authority. The principal was held liable for a contractor's death when he was hit by a mobile plant while on their site. The principal was held liable for a contractor's death when he was hit by a mobile plant while on their site and operated by their employees. So that makes total sense. You have an independent contractor come on your site. They're your forklifts. It's your site. They're your forklift operators. If someone gets run over by one of those forklifts, you as the principal will of course be held responsible. So the next one, C&J Carpentry. Principal was held liable for a contractor who fell through a void in the floor of a house being constructed. So again, site safety, the principal had a responsibility to make sure that people moving around the site or workers moving around the site, being their own employees or contractors or anybody else, couldn't fall through this void in the floor. So it makes absolute sense that yes, you as the principal have responsibility for site safety if you have control of the site, okay, if you are an occupier of the site. This one's quite similar. Ivory Proprietary Limited. A principal was held liable when a contract cleaner fell through inadequate scaffolding. So the scaffolding on the project was not right. The cleaner, who would have had no knowledge about scaffolding or whatever, came on site and fell through it. So obviously the principal who had overall management of the site had an obligation there and failed to meet that obligation. Now, this is interesting because not that long ago, Baiada Poultry decided to have another go at pushing this issue around contractors. And quite frankly, they pushed their luck and lost. And again, I think when you look at the circumstances of this case, you go, well, that was obvious. They were going to lose because essentially a cleaner came onto their processing plant, was cleaning around machinery and was killed while working at the plant when he became entangled in a chicken processing chain. And of course, their appeal against their prosecution was dismissed, and it was held that Baiada had control over the processing line. And to me, that is just obvious. The plant is controlled by a Baiada. The guarding of the plant, any lockout, tag out, plant safety, all of that is integral to the operations of Baiada. The contractor was there as a cleaner. It wasn't anything that was specific to the cleaning that was the problem. It was the fact that that piece of machinery was not locked out, was not guarded in a way that prevented access. Now, that access could have been from the cleaner, from another worker, from anybody. So it's really clear to me, and I'm sure to you all, that that was never going to get up. So yeah, so it's interesting. You've got the same, respondent, and they've pushed it too far there. And it really, I think, clearly shows you retain the duties over the matters over which you have control. So, what does this mean in practice? when we are engaging independent contractors. What we need to be doing is thinking about, well, when we engage a contractor, what is it that we need to know? We do need to demonstrate some due diligence when we're engaging a subcontractor, but that doesn't mean questioning an independent contractor about the ins and outs of their specific safety management systems. Just think about, do I have the knowledge to question a contractor's safety arrangements? What is the point of asking for a safe work method statement from a contractor whose business you have no understanding of? You're just gathering bits of paper. If you look at those safe work method statements and make comment on them or make changes to them, well, what does that mean? It means that you're actually effectively taking some control. And look, even if you say, all right, well, I'm going to engage an external consultant to come in and review these safe work method statements, well, that external consultant is acting on your behalf and essentially then telling the contractor how to arrange their safety. And that, to me, is risky. Is it practicable in respect of cost or effort to control a contractor's safety arrangements? The nature of the contract is you've said, I'm contracting out this job and I'm contracting out the entirety of the job, which means managing the work and the safety and how it's done and all that sort of stuff, that if I then turn around and employ someone or get a consultant or get somebody else to come in and then manage the contractor, well, that's defeating the point of the contract. And that's exactly what Baiada was getting at, where they said it's not in the nature of the contract to do that. And the cost and effort of going outside the contract to do that makes it not reasonably practicable to take on that role. What control do we retain? Are we bringing contractors onto our site? Do we have to manage their safety on our site? We certainly have to think about the hazards that we have control over on our site, where we are an occupier, all of those kind of things. And is it reasonably practicable for a principal contractor to specify and enforce arrangements to be adhered to by contractors considering knowledge in the contract relationship? So again, if you have an independent contractor coming in, is it appropriate for you to be dictating how they do their work and their safety arrangements in respect of the work that they are there to do for you? It's certainly appropriate to dictate safety arrangements in respect of your own undertaking, the risks created by the principal's undertaking, but it's not, well, and the High Court found it is not reasonably practicable to specify and enforce arrangements considering knowledge in the contract relationship on independent contractors. Sorry. Okay. Questioning our current practices. So the sorts of current practices that we do, and I see all the time, and like I said, just got asked to fill in a questionnaire the other day, asking for safe work method statements beyond that required under regulation. So as I said, outside of the construction industry and in respect of defined high risk work, we ask for safe work method statements from our independent contractors. Well, the case law would say, why do we do that? You're not expected to do it. There's questionable value in doing it. What do we do with them? If you review them, query and amend them, well, you're increasing your own liability. And supervising and checking compliance with safe work method statements. Again, there's a knowledge thing. How do you actually know what you're looking at? And if you're supervising it and you go in and you say, all right, you're not doing this or you are doing this and you need to change that, you are increasing your liability. So, what should we do? So when you engage contractors, yeah, we do need to go through a process of due diligence, but it can be a whole lot simpler than the sorts of things that we do see all the time. So we just define the tasks that the contractor is being engaged to undertake. I'm engaging you to clean the windows, and I want you to clean the windows on that building, and that building, and up there on the second floor and the fourth floor. Be really clear about what it is you're engaging them to do, where they're doing it, so forth. Define the obligations of each party over which each has control. So you will have a list of, and I'll go through them in a minute, you know, what are the obligations of each party? Just be really clear about that. You know, in a contract document, you can write a clause. I've drafted clauses which set out what those obligations are. Clearly assign responsibilities for work and risk management in contracts. So the independent contractor is responsible for managing risks arising from their undertaking. The principal is responsible for managing risks arising from their undertaking. And be really clear about that. Confirming a contractor's competence. So evidence of licensing, accreditation, membership of a professional body, those kinds of things, insurances and so forth. It's not about confirming competence by saying, all right, well, I want to see every, you know, I want to see safe work method statements. I want to see all your training records, all of those sorts of things. It's basically just confirming it. And I don't think it means asking them all the questions, you know, really detailed questions. Have your workers had training in safe chemical handling? Have your workers had training in work at heights? It's about a question which says, are your workers trained to manage the risks associated with your work? One question, yes, no. If you feel the need for a questionnaire, you can have one, but just make sure, you know, it can be really brief and concise and get to the point. So the sorts of obligations that the principal does have are, the principal needs to control the risks arising from the principal's operations. So if you've got forklifts running around your site, you need traffic management and you need to make sure the contractors are inducted into that and, you know, are safe in that respect. General site safety. So access, egress, how to get on, how to get off, what the facilities are, emergency response, evacuation, general, first aid. So basically the sorts of things you have in place for your own workers. Notification of serious incidents at sites controlled by the principal. So the occupier, notification of serious incidents at sites controlled by the principal. So the occupier of the site has responsibility to notify of serious incidents, notify the regulator. So they retain control for that, or they retain obligations. Selecting specialist contractors who are appropriately competent and or licensed to undertake work. If you need a licensed person, a plumber, an electrician, whatever, you need to make sure they're licensed. Ask them the question. It doesn't mean necessarily seeing their license, but asking the question. Consulting with contractors. So if you're going to make a change to your site or your work practices that will impact on contractors, you need to communicate with them about it. Inducting contractors into site safety rules and procedures, so things that are actually happening on the principal's site. So like I said, traffic management plans, emergency management, you know, all those kind of things that are specific to the principal's undertaking. Then you do have an obligation to supervise contractors with respect to compliance with site safety rules and relevant matters over which Company X or the principal has control. So you need to make sure that your contractors are signing in and out, sticking to the walkways, you know, following company rules in respect of those things. Coordinating contractors where there are multiple contractors on site. So where you know, I've got a couple of independent contractors here, they're going to be interacting, so I need to be making sure that there's a coordination role so everybody works in together and risks are managed. So you can see that's very much about, you know, what the principal has control over. Now, looking at the contractor's obligations. So what do they need to do? They need to give information to the principal or Company X, confirming that they are managing health and safety risks. Now, again, this is not necessarily about saying, I want to know if you're managing plant safety. I want to know if you're managing you know, work at heights or chemicals or, you know, whatever it might be. It can be a question, one question. Are you managing the risks arising from the work you are undertaking? Yes or no? So you've asked them the question, they're representing to you that that's what they're doing. They need to identify and manage all the hazards associated with the work they do in accordance with legislation. They need to ensure their work doesn't pose a risk to the principal's employees or others who are maybe impacted by their work. So if they're going to be working at heights and they're carrying things around on scaffolding which can fall onto people below, they need to be establishing exclusion zones and so forth. Now, in that situation, the principal, if their workers are going to be moving in around where the contractor is working, they would have a dual obligation to say, all right, well, I need to make sure my employees are not exposed to a risk. And the contractor also needs to consult when they're making changes that can impact on health and safety. They need to let the contractor know if there are any incidents which occur, provide proof of competence and or licensing if asked. You know, as I said, simply saying, okay, we're confirming that all of your, you know, workers are licensed to undertake this work. It's that kind of paperwork and administration that is really burdensome, and I think goes to that issue around where Baiada said, look, it is not practicable for the principal to be delving into, you know, the contractor's arrangements. I mean, you might say to an electrician who's got 10 electricians working on your site, oh, I need to see all their licenses. Well, in a week's time, they get 10 new ones. What do you have to get all those licenses again? It just becomes unmanageable. Contractors need to comply with site safety rules, obviously, and they need to provide any information. And sometimes it might be they need to give training to the principal for employees to ensure the safety of the principal's employees. They may need to provide additional first aid. If they are bringing in chemicals on site or anything that's at risk there, they need to have appropriate first aid response and additional emergency response. And they need to manage their own specialist contractors and hazards arising from subcontractor activities. So it's really about saying we need to be making sure that contractors are being advised of and taking responsibility for what they're responsible for, and the principal is taking responsibility for what they're responsible for. Where am I? Okay, so really, as I said, I find it distressing that, you know, we're often faced with really complex contractor management systems, which I know contractors find incredibly frustrating and sometimes offensive, because they sort of want to say, well, you're engaging me to do expert work and now you're trying to tell me what I'm doing. And I also think that principals spend a lot of time, you know, implementing these contractor management systems that are overly complex, overly cumbersome, and quite frankly lead them into liability, because they are effectively meddling in the safety arrangements of their independent contractors, when one, they may not have the knowledge, they probably don't have the knowledge to do that, and it is just not in accordance with what the whole purpose of a contract is about. So to recap, just briefly, I think it's really important to understand, I'm not saying, and these cases are not saying, you can contract out of your duties. You can delegate your non-delegable duties. What it is saying is you are utilising specialist contracts to meet your obligations. You are getting in someone to undertake this work on your behalf and to manage the risks that arise because of that. So it's quite a significant different mindset, but it's important to understand that that's where it's coming from, because I know people will say, but you can't delegate, you can't contract out of your duties, and they're quite right. But as we saw, the cases have been really clear about that. That is not the intention. It's basically saying I'm bringing in a specialist contractor to do work so that I can meet my obligations. Giano, are you there?
Yes, I am.
I don't know if Giano's there. I was just any questions? I was just wondering if there were any questions that had come in.
We've had a few questions come through. I'll read them out to you, and I'll read them out who's actually typed them through.
Yep.
And if you've answered them, just let me know.
Yep.
Okay, so the first question I had was a while
Sure.
ago from Jonathan. What are the real WHS duties and obligations of a principal contractor?
Right, so the real WHOHS obligations of a principal contractor are those set out under you know, the key obligations to eliminate or reduce risk so far as is practicable, and then, you know, and setting out what that looks like. So essentially, it is the general duty to eliminate or reduce risk so far as is practicable, and that is the underlying principle here, is saying what is practicable to do, you know, what is practicable to achieve those obligations with a contractor. If you don't have knowledge of how a contractor is doing their work, and they're a specialist contractor, so, you know, if you look at reasonable practicability, one of the elements of determining practicability is knowledge, and it's not only what you do know, it's what you should know. And you say, well, if I'm engaging a contractor to come in and do a specialist task, well, it's not saying, oh, well, you should know how that contractor does their work. No, that's why I'm getting them in to do it. So it's looking at, so it's essentially those core obligations under, the general obligations of principles under the Act. So the definition stays the same, it's reasonable practicability, but it's how it's actually applied that varies. Yes, next.
Thank you. The next question comes from Courtney. If you have a situation where you are locked into using a certain contractor, but you are aware that they have had safety-related incidents in the wider community, does this change your underlying...
Look, I think part of that due diligence and competence, and I think it's funny because I thought I had another slide there, and one of the elements is, look, when you engage a contractor, you would look at their safety performance and say, well, if they've had bad safety performance, that's part of your due diligence to say, well, maybe we don't want to use them. So yes, I don't think it doesn't change the duty. What it does is it changes, it informs you around whether you want to use that contractor or not. Now, this being locked into a contract, well, you need to look at the contract and go, well, is a breach of safety duties or, whatever. And go, well, is a breach of safety duties or, whatever, is that an essential term of the contract which then allows you to terminate? That's a legal contract question, not a safety question. But definitely one of the elements when you're engaging a contractor is to say, you would say to them, have you had what their safety performance has been like? So at the end of the contract, you look at it, say they've done work for you, might look back and say, well, actually you had a number of incidences, we're not going to use you again because that tells us you are not competent to do the work. So competence is not only about the work they're doing, but whether they did it safely as well. That's an element of the competence. So yes, I think you do look at that and you say, well, one, if I'm looking to engage a contractor for the first time and I know they've had a poor safety record, well, you probably wouldn't engage them. And two, if they've worked for you and had a number of incidences, you would look at that and refer and look at it and say, well, okay, do we want to use them again? Because that's part of their competence.
Okay, so another question from Courtney. How can the risks involved in contractors working within an operational setting they are unfamiliar with be managed without the micromanagement of SWMS/JSA, etc.?
So that's a funny question because what I'm going to, so where you say, so the question is, how can, just say it again,
so how
Gianna?
Can the risks involved in contractors working within an operational setting they are unfamiliar with managed without the micromanagement of SWMS and JSA?
Okay. So what I'm going to take that as is where a contractor is working in a principal's business or undertaking and they're not familiar with the risks of the principal's business. Courtney, if I'm answering this incorrectly, please write in again. So in that instance, you would take the contractors and say, okay, we need to make you aware of the risks associated with working in our business. So like with Baiada, in the recent case where they just pushed their luck, they had a cleaner coming in to work on their site. One of the risks was around plant safety. They had an obligation to train that cleaner. They also had an obligation to ensure that that plant was adequately guarded, locked out, whatever it might be. So that is a hazard that they retain control over. So it's not about safe work method statements. It's about saying we need to be making sure that our risks are managed. We don't want to be giving a contractor a safe work method statement to direct them in their own work. So I'm taking that as where the contractor is unfamiliar with the environment of the principal. Absolutely. I don't think safe work method statements are the answer. I have a real problem with safe work method statements in general, but what it is saying we have, as a principal, have to manage the risks that we create that may impact on our contractors.
Thank you. The next question is from Scott.
Next.
With principal contractors, example plumber, would you check to ensure that they have a current license and check to see if they have completed a JSA or a SWMS? This will ensure competence and that risks have been identified and managed.
And that is exactly the issue. No. One, you go, okay, I ask you the question, are you licensed? And I might even ask to see it if I want to. But the whole point is why, I'm not a plumber. I'm presuming, Scott, you're not a plumber. So even if I ask for a safe work method statement, what am I looking at? What am I assessing? What is it there for? You collect it, you look at it, and you go, okay, it looks fine, but what does that actually mean? And I sort of give this funny example. People used to say to me, well, surely it's obvious what some of the safety arrangements are. And they'd say, oh, well, what about a window cleaner? You can see where it's work at heights. And I'd say, well, what if a window cleaner turns up and says, well, actually, we've now got these new boots that are friction, they act as a magnet on the trestle we're working on, so we don't need scaffolding anymore. Well, I wouldn't have a clue whether that's true or not because I'm not a window cleaner. The whole point is that you are engaging specialist people to undertake specialist work. And, and further, the Baiada decision clearly said, even if you have knowledge about how they do their work, the whole point of a contract relationship is that you are utilising those contractors to undertake that work and they are responsible for managing that element of the work as well. So, no, I would not collect a safe work method statement from a plumber. You may ask them and I don't even think you would say, safe work method statements are not a legal requirement outside of construction work and regulation. Let's be clear. They are put forward as, oh, well, everyone has to develop a safe work method statement for everything they do. No, you don't. So, if I had a client once who was asked to prepare a safe work method statement for sticking decals on a window, and, safe work method statements and JSA are only one way by which you can go through a process of identifying hazards and documenting your risk control. There is nothing wrong with a contractor verbally, visually, looking at a site, looking at risks and saying, right, we know what the jobs are and we're going to do this, this and this. The only reason why we document it is to provide us with an evidentiary basis if something goes wrong. So, no, I would not ask for safe work method statements, and that really is a part of the crux of what this case is all about.
Now, this presentation is focused on principal contractors and subcontractors. Does this also apply to a business getting an independent contractor?
Well, it's focused on independent contractors. That's what the whole session is about. So don't worry about subcontractor. Basically, it's focused on principal contractors engaging independent contractors. So the term principal contractor means employer. So it's about an employer engaging an independent contractor who is coming in to do a piece of work. So it's not labour hire and temporary labour who are there to do work that you've got control over, but it is absolutely about employers / principal contractors engaging independent contractors / subcontractors. Okay.
Thank you. The next question comes from Carolyn. How do you view contracts such as cleaning contracts, which are not particularly skilled work?
It's the same issue. The cleaning contractor themselves has an obligation to manage the risks arising from so say for example chemicals. So using, if a cleaner's going to use chemicals and so forth, they have an obligation to manage those chemicals, they have an obligation to manage the manual handling risks, they have an obligation to manage those things. The principal has the obligation to manage access, egress, such as in the latest Baiada case, if there are hazards which are posed by the principal's undertaking to the cleaner, plant, traffic management, forklifts, all that kind of stuff, then yeah, the principal's got to manage those. So I don't think it's about the skill or otherwise of the staff undertaking the work. It's about the principal being really clear with the contractor and saying, you are responsible for managing, and I am contracting you to clean the factory, clean the offices, and manage the risks arising from that. So if they're coming in to vacuum the office, then it's up to the cleaner or the cleaning contractor to manage manual handling, trips, and so forth. If the principal supplies the vacuum, different issue. The principal then has to test and tag the vacuum and look at its manual handling or look at, you know, its design or whatever. It's really about thinking, what have I got control over? If my cleaners are coming in, they provide their own chemicals, they provide their own electrical equipment, vacuums and so forth, then they are responsible for managing those things, and you make it contractually very clear that that's the case. And essentially you're bringing in those contractors to do that for you, to meet your obligations to, you know, manage those risks. So I don't think it matters about the level of skill, it's the relationship. Next.
Thank you. So we have a question from Karen. Why does WorkCover and ComCare promote the responsibility is with a PCBU to monitor and control safety of contractors? Example, Kirk versus WorkCover.
It is a responsibility, but it's how it's discharged. Okay, so essentially, and I mean ComCare and WorkSafe and ComCare basically on about saying you do have obligations to your contractors. Absolutely you do, and I'm not saying you don't, but it's how that duty is discharged. And it's how far does that go. And, you know, if you talk to WorkSafe outside of the construction industry program, you know, there is that recognition that essentially, you know, you've got independent contractors, they come in to do their work. If they have an incident, then essentially WorkSafe will come in, say to the principal contractor, okay, well, you know, you were managing what you've got control over, we need to look at the contractor. So it's not about saying, and I kept stressing this through the presentation, it's not about saying there are no obligations. It's about saying how do we discharge that obligation, and how that obligation is different from our own employees because of the level of control and those elements of practicability around knowledge, cost and effort of trying to treat our contractors as our own employees. And it defeats the whole purpose of bringing in a contractor. You know, if you're going to basically tell them how to do their job, well, why bring in a contractor? Just train someone to do it for you and employ them directly. So yeah, so yes, ComCare, WorkCover, WorkSafe, all the regulators say you've got obligations to contractors, and you do, but it's how that is actually achieved. Next. Gianno?
Thank you. So the next question is from Raymond. What about checking logbooks, lift plans, etc.? Yes.
Logbooks, and what was the next bit?
The next question is from Raymond. What about checking logbooks, lift plans, etc. for plans that come to site?
So logbooks in terms of...
So logbooks, lift plans.
You're just fading out there. Logbooks, lift plans, and... Hello?
Yep, so it's what about checking logbooks, lift plans, etc. for cranes that come to site?
Cranes. Right, okay. Again, you know, this is the independent obligation, contractor's obligation. You know, you bring in a crane company to do a specific job. It is up to them to make sure that chains are all rated and logbooks are kept and lift plans are designed, all of that kind of stuff. So no, you don't ask for them. You know, and I've worked for a company where we used to get cranes in all the time. And essentially we engaged a competent and, you know, experienced crane company and said, you need to... So we would isolate the area and say, crane, you have to go and work over there and do your thing, and we keep our staff out of the way and you manage the risks associated with that. And we actually had a chain break and a collapse. WorkSafe weren't interested in us. They're interested in the crane company, you know, because we don't have, one, the knowledge of anything, we don't know anything about cranes, and the cost and effort of interfering or of questioning that crane operator about what they're doing is just not in keeping with the whole contracted arrangement. So actually, no, You don't ask them for their lift plans because that's like a JSA for a planned lift with a crane. So no, that's not what you do. And I think we go back to, if I just flick back here, there was the comment which was made, sorry, with the, this, I'll just go back here and see if I can find it. The, this, I'll just go back here and see if I can find it. The, oh, this is so annoying. Yeah, see here, provided that the contractor was competent and provided that the activity was placed in the contractor's hands, you know, the principal was not subject to an ongoing general law obligation with respect to the safety of the work methods employed by the contractor. So, you know, I've contracted you, I've handed the job over to you, and I've stepped back. So I'm not going to come in and be checking your safe work method statements, your, you know, and the technical aspects of how you're actually going to do that work.
Okay, the next question is from Brett.
Right.
What about chain of responsibility in the transport loading issue? Could it be a different outcome under the new COR framework?
Yeah, okay. Sorry. Yeah. So chain of responsibility, so in terms of transport, definitely there are obligations on all elements of the chain to make sure that each part of the chain is not putting the next bit of the chain at risk. So the consigner is making sure that the, you know, delivery and the delivery time frames and all the rest of it are adequate so that the transporter can get there in time and take appropriate rest breaks and all of those kind of things. So there definitely are obligations where that's concerned, definitely. But, you know, it's about clarifying in that situation, again, who has control over what and what are, so, and if you think about it, you go, well, Poltec in Baiada was probably a good example. They were going out to the farm to collect the chickens, put them in the pallets and load them on the modules and so forth. Now, that safe work method or the method by which they would load them onto the truck and so forth was a very specific thing within their contracted obligations and their job. Now, the chain of responsibility in terms of, you know, load restraint and timing around delivery and all of those things. So it's about how each element within that chain affects the next element, and it's a good question and it is important to think about that. But I still think the risks that fall within the specific expertise of each element of the chain are impacted on by these decisions as well. So we need to think about that a little bit differently. But certainly things like, as I said, the construction regulations and chain of responsibility create a slightly different application in this situation. But I still think these cases have applicability in terms of how far you actually go in directing those contractors.
Instead of dictating arrangements, what about offering improvement suggestions and leaving responsibility with the contractor?
Well, the problem with offering improvements and suggestions is, well, are you tacitly telling the contractor what to do? You know, and I've been in this situation where I've gone in and a principal is concerned about the safety arrangements of a contractor, but they want to use the contractor. I think that by far the best way to deal with that is to say to the contractor, you need to get some safety advice and get them to go off and get their own advice. Instead of the principal interfering or even engaging a consultant to go and, you know, tell that contractor what to do, who is acting on behalf of the principal, say to the contractor, I'm concerned about your safety arrangements. To enable you to work for us, I think you need to go and get some advice. So they've gone off, they've got their own advice, it's independent of the principal, and that contractor, the independent contractor, is responsible for adopting or otherwise of those instructions. The problem is independent contractors, if they're told to do something by a principal, if they want, you know, if they want to get the work, they'll probably just go, oh, okay, we'll do it. And I've seen where contractors have said, this is ridiculous what they're making me do, because it actually takes me longer and it's not even any safer or it's less safe. So I think it's really good to keep that arm's length and say, Mr. Contractor, you need to go off and get some independent advice. So that's how I would handle that. Yep.
Thank you. The next question is from Scott. Are we expected to ensure the contractor is managing their risk, or do we just assume the risk is being managed because they are competent?
Well, the question, and really the situation is that we make sure they're competent, and then we assume that they're managing their risk. Well, we don't assume it, but we put that obligation, we put the obligation on them to manage that risk. So we engage, we have some due diligence. Now, if you want to give a little, and I know people find it very distressing to let go of questionnaires and surveys and things like that, if you want to have a little questionnaire to say and ask the question, are you managing the risks arising from your undertaking, yes or no? Just so you can say, well, we asked the question and they represented to us that they were. But, essentially we say we've engaged a licensed, competent, referred member of the professional body, whatever it is, provider of these services, and it is the well, it's not even the expectation, it's just that, they will be managing those risks. And the law has clearly come down on the side of, it is just not in keeping with how contracts work for principals to keep getting involved and overriding what it is that that an independent contractor is doing and the arrangements that they are making.
Thank you. So the next question is from Raymond. I always insist on photocopies of all licenses so that I have proof of both competency and currency. Simply asking the question is both rubbish and undocumented. IMHO. I believe that might be a
yeah.
comment.
Look, I think the thing, and look, I understand where you're coming from. People get really frightened by this stuff. They just go, but hang on a minute, I'm letting go of control. So, okay, you get copies of licenses. So you've got 10 drivers come in, they all give you licenses. The next day, 2 of those drivers change. How do you stay on top of this? It's just not practicable. And it's interesting. I mean, I work for a client and we had drivers attending the site every day. Coming in, dropping off, going out, all the rest of it. And I had this discussion with WorkSafe and I said, we asked we had quite a number of contractors who had drivers who were coming in, dropping off and all the rest of it. And I said, we just can't, they might send us one driver one day and then a different driver the next. We just can't keep track of, and it is not practicable for us to be doing what the independent contractor needs to be doing, which is keeping people's licenses current. And so, I understand the comment and I sympathise, and people get very, very anxious and they go, but how can I let go of control? Well, I mean, my argument would be is you're not in control anyway, because stuff changes and you just cannot stay on top of it. And it's not practicable to be constantly asking your independent contractors to say, well, you need to show, every day, every time a driver comes in, do I see their licence? That is a reasonable expectation on an independent contractor to say you will supply licensed drivers. Next.
Thank you. So the next question is from Linda. What if you see a contractor doing something you wouldn't accept on your own staff to be doing, manual handling?
Look, and it's an interesting question, and it's one that people do ask. They go, "Oh, am I supposed to just walk past, something that I can see is going wrong?" Look, the legal position is essentially the job has been handed over to the contractors and they need to manage it. Now, from a moral perspective, a reputational perspective, I mean, there are lots of reasons why we want to take more control over a contractor. And it's not always a legal issue. It can be, well, I morally think that I should be getting involved in their safety arrangements because I want everyone to be safe. Or I can't afford for a contractor to have an incident on my side, and so I feel the need to take really high level of control. I mean, I think that's problematic because you're introducing, you're increasing your own liability. So a choice, can be made to say, and I mean, just on the basis of this law, employers can say, well, actually, we want to take more control because that's just what we want to do. But be aware of why you're doing it. You're not doing it because it's a legal requirement. You're doing it because that's what you feel you need to do, or you want to do it for whatever reason. So strictly speaking, if a contractor is working away and you've handed the job over to them, then essentially you leave them to it and they essentially get on with their work and they manage things accordingly. From a moral perspective, from the outcome of keeping people safe at work, sure, you can step in and go, hang on a minute, I don't think we think that's safe. you know, that's not in accordance with how we would normally do things. We suggest that you do this differently. But just be clear about why you're actually taking the action and, you know, any potential consequences that might flow from that. Next.
Thank you. The next question comes from Shelley. How do the 2011 changes from employees or contractors to workers?
So how do these, what was that? Say that again.
How do the 2011 changes from employees or contractors to workers?
There's no change. It's just a term.
Sure.
It's just what you call them. There's no change. There's no difference. Yep. Next.
Not a problem. Okay, so the next question is from Bethany. Does the ownership of the location or site where the event occurred have a bearing on the court's decisions? Example, Hooden owned the location, not Baiada.
Yeah, and look, it's a good question, and in that case, yes, it was off-site. Yeah, and look, it's a good question, and in that case, yes, it was off-site and all the rest of it. But what's clear is it's about, as I said, when a principal has a contractor come onto their site, they are responsible for managing the risks arising from their undertaking. So if I have a contractor come onto my site and I've got forklifts running around, I need to make sure that that contractor is safe from my forklifts. So the principles remain the same. The contractor is responsible for the work they are doing and the risks arising from their undertaking, and I am responsible as the principal for the risks arising from my undertaking. So no, it doesn't matter that the contractors, you know, working off-site or on-site. The same issues. I mean, arguably, if they're working off-site, then the principal has even less control. So you know, you would make the argument more strongly to say, well, we didn't have any control because we're not even there. But I think the better way to think about it is to say the principal needs to control risks arising from their undertaking. The contractor needs to manage risks arising from their undertaking.
Question from Shelley now. It goes, how do the 2011 changes from employees to workers impact on these decisions? My understanding is that the principle of control has been minimized and that we should be treating contractors as workers.
No, that's not correct. So basically, you know, it's just a change of terminology. So workers are employees and contractors are still, and as I said, contractors are workers for the purposes of there is an obligation under the OH&S Act towards those contractors, but it's what does that obligation look like and how do you meet that obligation? And what these cases are saying is it is different how you go about. With employees, you have direct control. You tell them how to do their work, you give them their equipment, you manage the risk, you know, all of those kind of things. You are creating the risk. But what this is saying is contractors, whilst they are workers, sure, for the purposes of OH&S, the way you meet your obligations is different, and the way the way those obligations is discharged. So no, contractors are not the same as your own workers. And I think actually, where did we go back here? There was a comment back here just about. I can't jump around on that because it's going to make too much noise. But yeah, and this decision was in 2012, so it was after those changes came into place. So no, contractors have not been brought in under the same level of obligation as our direct employees. Okay, I'm noticing it's 22 past 5, Giano. What time was this meant to finish?
Like, we can end the webinar there, and any questions can be then forwarded to you if you like. I mean,
no, I'm happy to keep going for a little bit. Maybe if we go to 5:30, and then
so the next
people want to send questions in, that's fine.
Hi Sue, using your example of W&H, we regularly engage contractors to clean gutters. We currently permit this work due to the high risk nature. This requires use to get the contractor to risk assess the activity and develop an SWMS. it's used to get the contractor to risk assess the activity and develop an SWMS, which we review and approve. Is this overreaching?
Yes, it is. Yeah, because, you know, the reality is you're engaging someone to clean gutters. The risk is work at heights. And the contractor has an obligation to, you know, the contractor has to look at that risk and manage that risk. And by you reviewing and approving the Safe Work Method Statement, you have just put your stamp all over that and said, we think that's a safe way to do the work, and you've increased your liability. The reality is that's why you've brought in contractors. You need to confirm, and, you know, confirming that they are competent to undertake this work. So when you're engaging them, you say, look, this is going to be a cleaning job where you need to get up at heights. Are you able to manage that? And the contractor says, yep, we're able to do that, and we'll be implementing systems to do that. So, yeah, it is an overreach. Yes, it is. Yep, next.
Thank you. Okay, the next question is from Penny. Hi, Sue. We have large sites with contractors who are on site all day, every day. What do you suggest we do as a regular management of the risks in their work?
Now, if these contractors are on site all day, every day, because they are effectively working for you, they are effectively your own employee. So I worked for a company, we had maintenance fitters, and those maintenance fitters worked for us Monday to Friday, 5 days a week. They were our employees, so they're not really contractors anymore. You know, they may be contractors and they've set up a contract company so that they can, you know, have an ABN, and there's all sorts of corporate reasons why people are in, you know, set themselves up as independent contractors. But in that situation, they're effectively the same as your own employees, and you've got control. I'm assuming you've got control over them. You direct them. You tell them what work to do. You give them equipment. All of those things. So you need to treat them the same as your own employees. If for some bizarre reason you had a completely independent expert contractor working there in the longer term, then, you know, this is really about independent contractors that come in to do a job. They're not there all the time, and they're not doing what is core work of the employer, because, yeah, and whilst they may call themselves contractors, they're really deemed employees, and you'll find that they're a deemed employee for workers comp, and you really should be treating them as the same as your own workers, because you're maintaining a high degree of control over them. Yep.
Okay, thank you. So the next question is from Timur. Can a contractor specify in the contract that they discharge their OH&S legal obligations to you as a business owner?
No, it's the same. They can't put it back to you, and you can't put it on them. Like, nobody's delegating duty, and no one's contracting out of duty. That duty will remain. So if a contractor comes on board, so say, for example, let's use the crane because it's pretty easy. So the crane contractor comes on board and says, well, actually, I don't want to take responsibility for whether or not my lifting plan is right and my chains are safety rated. I'm going to put that back on you. They can't do that. You know, these are inherent obligations around the risks arising from their undertaking. So no, they can't. You can't do that by contract. And please be clear here. The contract between the principal and the independent contractor is just clarifying what the obligations are. It is not shifting them. It is clarifying who is responsible for what. And it is clear in the case law that those responsibilities were always held by those parties. But it is just making it really clear who is going to do what and where that responsibility falls. So no, they can't push it back on you.
Thank you. And Kim asks, what if there are no other local contractors in town that undertake the specialist work and there is poor safety performance? You
have to make that call. You know, this is the thing. I mean, and it happens, you know, some areas there's unfortunately a dearth of independent contractors to use, and sometimes you might say, oh, well, and so then you might say, okay, well, because we know this person's got a bit of a funny record or whatever, we might increase our supervision of them or so forth. But, you know, it's problematic. I really would take the path of saying, look, we're not happy with your safety performance. We are going to require you to go and get some advice and get some assistance to help you manage these risks as part of the contract. Difficult when they're the only one, and so they've probably got you over a bit of a barrel. But yeah, if you engage a contractor where you know they've been unsafe and had issues before, it would be a bit risky in terms of your due diligence. But yeah, it can be difficult in the real world. Yep, perhaps we make this the last one.
Thank you. Okay, so last question. If a local council, let's say rather than SWMS, we would be more likely to require to disclose the risk associated with them entering our site. The contractor engages all subcontractors, etc. Can the local council not need to review or inspect?
So is the question that essentially, so the question is, we're engaging contractors as the council to come on site. Those contractors are engaging subcontractors. Do we need to review the safe work method statements of the subcontractors and the contractor? And I would be saying, no, you don't. And that's the whole point, is essentially we're saying you are the contractor and you have the responsibility for managing the risks arising from the work that you are undertaking. And I'm not looking at your safe work method statements because I may not even know what I'm looking at, and the cost and effort of requesting that documentation, reviewing it, and then supervising compliance, well, the case law is clear and it just says it's not practicable. The case law is clear and it just says it's not practicable. So no, you wouldn't. No. And I do want to hammer home this whole, explosion of requiring and getting workers and employers or contractors and that to write safe work method statements seems to have grown its own legs. It is not a legal requirement to write a safe work method statement for every work task you do. It is defined under certain regulations that is a requirement, but it is just one tool by which people, can look at, identify risk and develop hazards. There is no legal requirement to write a safe work method statement. And so, we just say to the contractor, look, it's up to you to manage your risks, and they may say, well, we don't write